just a few minutes ago, we saw President Trump make his way to that federal courthouse. Obviously, we didn't get a chance to see him, but we did follow his motorcade as he made his way. All right, so joining us now is Scott Tenley, former federal prosecutor, joining this morning to talk a little bit about these federal charges. Scott, thanks so much for joining us. Good to see you again.
Happy to be here. Thanks for having me.
All right, so break it down a little bit. What is going on inside the courthouse? Because we know this is a federal case, which means we don't see a lot. So what can you tell us that they're going through? And also, what's the next step as the court prepares for this arraignment, a huge arraignment?
So today in court, we'll see basically two proceedings. One is the arraignment. At the arraignment, which happens in every federal criminal case, the defendant is read his constitutional rights, like the right to trial by jury, the right to an attorney. And then he's also confirmed to have received the indictment and understand the charges against him. He may even be offered to have the indictment read to him in open court, which he will likely waive. And then he'll be asked to enter a plea. And in 99.9% of cases, the defendant will plead not guilty. So that'll be the arraignment. He'll enter his formal not guilty plea. The second part of the proceeding in federal court is what we refer to in Los Angeles as the detention hearing. Anybody who comes into the federal court system as a defendant is ordered to be released under federal law under terms and conditions that ensure the defendant will return to court and ensure the safety of the community. Now, in President Trump's case, there's no way he's going to get detained pre-trial. He's also very recognizable. And really, now that the classified documents have been returned to the government, there doesn't seem to be much danger. So I don't think we'll see any onerous terms and conditions, which could be, for instance, restricting his travel, surrendering his passport, things of that nature. But we will see some type of release order for the president, which will require him not to commit any further crimes, to obey all court orders, and things of that nature. So we'll see kind of two proceedings within today's hearing. And as I understand it from the reporting we're hearing, he'll be processed on his way into court. Sometimes that happens before the hearing, sometimes after. And that's where he may have his fingerprints taken. I hear there will be no mugshot, but that's kind of a back-end process that's in private, and then he'll be released and be on his way.
Now, talk to us a little bit about his legal team. We know that he lost a couple of the members and trying to get new members on the team. Maybe their expertise is not quite up to par, perhaps. What can you tell us about how this may impact things?
Well, for purposes of today's hearing, it's really a kind of a perfunctory hearing. So whoever is representing him today is not necessarily going to be the lawyers or lawyers that will represent him at trial. But what we are reading is that he's interviewing some very prominent Florida defense attorneys to join his team. We've heard of David Marcus, who just secured an acquittal for the former gubernatorial candidate in Florida. I've heard he was interviewing William Barzee, who's a well-known South Florida attorney. I tried a case with him about 10 years ago in Manhattan, phenomenal trial attorney. So he's reaching out to some of these people that know the Florida legal communities, because it's important to have a counsel who understands the kind of complexities of a district, of the jury pool, who understands how the court works, what procedures it follows, and then he can supplement those with outside attorneys and advisors as he sees fit. I think what's really difficult with respect to this search for who's going to represent him is that President Trump is obviously a very difficult client to control. He's going to be speaking about this indictment. He's going to be dictating strategy. The things he does outside of the courtroom may not be best for him inside the courtroom. So there are a lot of kind of complications when an attorney thinks about taking on this representation. And that's especially true when you see how President Trump has cycled through many, many attorneys over the last couple of years, some of whom have gotten paid, some of whom have not. But it would be kind of the case of a lifetime for whoever takes it on. There's never been any case like it. There probably will not be a case like it again. So he will be searching for his attorneys probably over the next couple weeks.
Yeah, and Scott, talking about speaking out, President Trump did speak out today before he went to his hearing on social media. He posted, I'm reading this right now, it says, before heading to court, he says, one of the saddest days in the history of our country. We are a nation in decline. So obviously, he is still continuing to say that he is not guilty. But I want to talk a little bit about this investigation because 37 counts, federal charges, that is a lot. So talk to me a little bit about this investigation and what goes into it and how much time it actually takes to indict someone like this.
Well, if this had been a kind of standard criminal investigation at a U.S. attorney's office, this could have taken a year or more to do because there is a tremendous amount of evidence that was gathered, and a lot of court proceedings to compel testimony that was obtained.
We're gonna pause you for 1 second because we're gonna listen to President Trump's spokesperson speaking right now. Let's go ahead and listen in right now.
Donald Trump. What we are witnessing today is the blatant and unapologetic weaponization of the criminal justice system. The Biden appointed special counsel has sought fit to bring 37 federal charges against President Trump, the leading frontrunner, less than a year and a half before an election. Countless other individuals, Hillary Clinton, Joe Biden himself, retained possession of classified documents, yet have not been prosecuted. And none of them came into possession of those documents while they were president. None of them were president who, as the head and sole member of the executive branch, has the power to summarily declassify documents. The decision to pursue charges against President Trump while turning a blind eye to others is emblematic of the corruption that we have here. We are at a turning point in our nation's history. The targeting, prosecution of a leading political opponent is the type of thing you see in dictatorships like Cuba and Venezuela. It is commonplace there for rival candidates to be prosecuted, persecuted, and put into jail. What is being done to the President Trump should terrify all citizens of this country. These are not the ideals that our democracy is founded upon. And this is not our America. Thank you.
So what's happening right now inside the courthouse? Has he been arrested? Has he been fingerprinted? Has a mugshot been taken? Walk us through what's happening here now.
President Trump is in a very unique position where he doesn't need to be given a mugshot, obviously. He is not a flight risk. He is the leading candidate of the GOP at the moment. He is going through a process that has been coordinated with Secret Service, and it will all be handled seamlessly.
And thank you, guys. The attorneys, what is his state of mind? Just real quick, how is he feeling?
He's defiant.
You've been hearing from the former president's spokesperson who said that what the president has been going through is like a dictatorship, something that would happen in Cuba and Venezuela because a blind eye was turned to Hillary Clinton and even Joe Biden when they had similar documents, yet they are targeting the former president, the frontrunner of the GOP party. Let's hear your thoughts on what she just was saying. Could you hear her?
I could. I mean, here's my reaction. I think a lot of what we heard was made for television, and it isn't entirely accurate when you really scrutinize the distinctions between what happened with President Biden, Secretary Clinton, and now President Trump. The critical difference between all these cases is obstruction. Secretary Clinton was cooperative. President Biden has been cooperative. Vice President Pence was cooperative. But as the indictment lays out, President Trump specifically took steps in concert with others in order to obstruct a federal criminal investigation. And that just isn't consistent with the rule of law. Now, I will say this. I think generally there is something to the point that we don't necessarily want to bring charges against a leading political figure that is challenging the sitting administration. I think in close cases, that's going to counsel against bringing charges. This is not one of those cases. That is the distinction. This is a case that once you hear and you read the evidence, you think, how could the government not prosecute this case? How could the special counsel decline to prosecute when there's evidence that suggests former President Trump expressly tried to subvert the rule of law, the requirements of a federal grand jury subpoena, and was holding classified information he knew he should not have kept? It's not a situation where it was mixed in with his papers. He kept these documents for a purpose, for a reason, and he knew he shouldn't have them. And so that's why this isn't kind of one of those borderline cases where discretion might say it shouldn't be prosecuted.
Yeah, talking about these charges, I want you to put it like in layman's terms for somebody who's watching it to kind of have an understanding of why these charges are so serious. I mean, when you're talking about threats against our national security and releasing information about our military and potentially other foreign countries, break us down a little bit what these charges mean and how it does affect our national security according to this indictment.
Well, we do have some sense of what these documents say and what they were about, and that is the vulnerabilities of the United States and our allies to attack, about our defense and nuclear programs, and about our plans for retaliation against foreign actors if they attacked us. They are our most sensitive secrets. Now, in the United States Attorney's Office in Los Angeles, where I was a former employee, we have national security prosecutors. And when they view materials like this, they have to go into a secured room that I've never even seen the inside of, that I could never even get into, let alone look at the documents. They have security clearance. They take background checks. They use secured computers. There is a tremendous amount of safety and security around these types of documents because of the risk of dissemination and the results that might reap if they were to get in the wrong hands. So, that's the big thrust of this is President Trump retained a number of documents, many of which were top secret, which are among the top classification of our documents in the military system, and they put us at risk. And that's the way that the special counsel framed this case when he gave his press conference on Friday, and that is, we have men and women on the front lines fighting to protect the safety and security of our nation. And by treating these documents, by filing them in his bathroom, in his ballroom, mixing them in with other things, flying them to Bedminster to evade a grand jury subpoena, that is what has forced the government's hand to bring these charges.
Can you talk a little bit about what will happen once the arraignment is over?
Okay, a couple things are going to happen. I think that what we're going to be most looking for is this is when Judge Cannon will step in. So at today's arraignment, a magistrate judge will be handling that. That's kind of a lower level judge that assists district court judges, trial judges. After today, the case is in Judge Cannon's court, and she will be able to likely meet with the parties and start working on setting a schedule, which includes when are motions going to be filed, when is discovery going to be produced, and discovery is documents, evidence, testimony that's been gathered in the investigation, and kind of working with the parties to get the case on a schedule to be tried. Ultimately, it will remains to be seen when that will be. But there's going to be a lot of skirmishes that come up along the way. Here are just two examples. First, some of what appears to be the most powerful evidence against President Trump is going to be information from his attorney, Evan Corcoran, who took contemporaneous notes about President Trump's discussions about, plucking documents out, how he was going to respond to the subpoena, and who then also took voice notes, which is incredibly devastating evidence. But that is typically confidential and doesn't get to the government because what is said between an attorney and a client is secret. However, the government applied to the district court in Washington and said, listen, Judge, an exception applies to that rule of attorney-client privilege. It's called the crime fraud exception. Mr. Corcoran's services were used to commit these various crimes, including obstruction, and therefore the privilege doesn't apply. We should get that otherwise secret information. And the court agreed. Now, I can see President Trump's team trying to relitigate that in Florida to try to figure out a way to keep that evidence out of the trial. The second thing I think we'll see litigated is how is this classified information going to be disclosed and used in public court proceedings? There's a legislation called the Classified Information Procedures Act that governs that sets forth how that will happen. And I also suspect that when the special counsel chose what documents to highlight as specific counts of the violations of the Espionage Act, he thought about those things. What can we have out in the open as opposed to some of the most guarded secrets that he doesn't even want to litigate over how to handle them in open court. But those are going to be two of the many big battles that will come, and I expect to see some pretty hard-fought litigation again among Trump's team and the Department of Justice on those fronts.
Yeah, and I also think it's important to talk a lot about, Trump's close aide, Walt Nauta. He's a Navy veteran who basically was Trump's valet at the White House. He went on to work with Trump at Mar-a-Lago, and he's accused of moving boxes from the White House at Trump's direction and then lying about it to investigators. So talk to us a little bit about the charges that he's facing, because Trump is facing the 37 charges, but Walt is also facing charges as well.
Right. So Nauta is not facing the Espionage Act charges, which are the ones that carry very significant sentencing and penalties. He's involved in the obstruction charges, and that is he was assisting President Trump in obstructing the Justice Department by purposefully moving those boxes of documents and potentially classified material out of Mar-a-Lago. And then when he was interviewed by the FBI and the government about what happened and what he knew, he claimed, yes, sorry, I can't help you. I don't know anything. But as we read through the indictment and based on text messages and statements of other witnesses, he was intimately involved with the location and movement of those boxes. So right now, I suggest he's likely an individual who's feeling a tremendous amount of pressure. On one hand, he, I'm sure, has a lot of loyalty toward President Trump. But on the other hand, he's facing potentially a felony conviction. He's a member of the armed services. He could be court-martialed. This is something that could impact his life for the remainder of his life, regardless of how long his jail time would be. And on something like this, it's minimal, not more than 5 years and probably significantly less. But nevertheless, it's never a position you want to be in. And he's going to be asking himself, do I do what's in my best interest, which is probably pleading guilty and telling a jury and the government exactly what happened, or does he stand firm and potentially go down on the Trump ship?
Let's talk a little bit about what the former president is facing. I mean, you're talking about several years, not as much for his aide, but let's talk about, do you really think that the president could be sentenced to time?
Well, there's a couple different ways to answer that question. The first is, let's set aside the president. So if somebody were accused of this crime, we would use what's called the United States Sentencing Guidelines to calculate what that sentence would be. And there's a specific provision of the guidelines that kind of forms what we call the offense level for mishandling classified information. And it's even higher when the documents at issue are top secret. So right there, you're looking at one of the highest levels on the chart, which is a level 35. And that's going to be 10 to 12, even more years for President Trump. Now, that's just where the sentencing starts. The judge always has the ability to go down. So this is where Judge Cannon kind of comes into play, because the judge has tremendous discretion at a sentencing hearing. The judge can decide whether to apply the guidelines range or to vary downward. And certainly Judge Cannon might find, hey, listen, I don't need to sentence President Trump to a term of imprisonment for the following reasons. And provided all those reasons are within her discretion, it's a very difficult sentence to appeal. So really, it could be anywhere for most people. This is jail time. On June 1st, in the Middle District of Florida, so north of Miami, there was an Air Force captain, retired after 29 years of service, who was sentenced to 3 years in prison for having about 300 classified documents. So there is some precedent for this. I don't know if those were top secret documents. There's also no indication of obstruction. So really, to think that this won't have jail time really comes down to Judge Cannon, but there is an incredibly realistic possibility that if President Trump is convicted, he will have a federal prison sentence. All
right, Scott Tenley, former federal prosecutor, we love getting your insight on this case as we move forward in an unprecedented moment in U.S. history. Thank you so much. If you want to stay with us, we'll be back with you in a little bit.